Hi, I'm Will Hughes, and today I want to continue introducing you to the basics of construction contract law. The topic of this video is the English legal system and the way that it supports and provides the context for what we do with construction contracts. So the first thing to cover is the structure of the courts. This is a very bare bones outline, not a comprehensive review of the structure of the courts, which of course is far more complex and for which you probably need to consult a legal textbook. But for our purposes, we can just skate over the details and focus on the parts that matter. First of all, you've probably heard of the magistrates' courts, where many legal cases initially commence. But the magistrate courts are mostly for criminal matters, criminal law, rather than civil law. Some civil cases start there, but most do not. At the next level, we have the county court, where most civil cases begin. And the county court is the level where many construction disputes would occur in the first instance. Above that is the High Court, and the High Court is split into a series of different divisions. Of interest to us is the Queen's Bench division. The Queen's Bench division of the High Court deals with appeals from other courts and also many first instance cases. A subset of the Queen's Bench Court is of particular interest to us, and this is called the Technology and Construction Court. This is a special court that's been set up to deal with complicated disputes, in particular disputes relating to buildings, engineering and surveying. They typically only deal with cases where more than £250,000 is in dispute, but they will deal with others on specific points of law. The next one above the High Court is the Court of Appeal. This court appeals only on points of law. And finally is the UK Supreme Court. This role used to be held by the House of Lords prior to the Constitutional Reform Act of 2005. But now the UK Supreme Court is the ultimate court of appeal. What's interesting to us is that all cases that are reported in law reports will identify which court they've been heard in, where the judgment arises. And this is important because of the law of precedent. The law of precedent is about when judges actually make the law by making their decisions. And this involves a hierarchy because each court is bound by the decisions of previous courts. But this hierarchy of courts, through magistrates, county court, high court, court of appeal, and so on, means that the higher courts can always overturn decisions of lower courts. So a court is always held by decisions from an equivalent or more senior court. This is why it's important for us. When we're reading construction case law, we need to understand which type of court took the decision, and that helps us to understand how secure that decision is, because the higher courts tend to take decisions that overrule all junior courts. So how the courts work, if you find yourself involved in a construction dispute, first of all, we have to think about the burden of proof, because some cases are criminal cases where the Crown takes action on behalf of the country, the prosecutors act for the Crown, in cases where people have broken a law, broken a statute. So criminal law is a particular kind of law for which there are other courts, including the ones that we've mentioned. But primarily we're interested in civil law. So the difference between criminal law and civil law is that in civil law, parties take action against each other, and therefore they're not taking action on behalf of the Crown. So in criminal law, people are prosecuted by the state. In civil law, people sue each other. And that's a significant difference. Probably the most important difference is the difference in the burden of proof. In criminal law, the burden of proof is that the court has to be persuaded beyond reasonable doubt that the claim is correct. Whereas in civil law, the burden of proof is simply the balance of probabilities, where one version of events is more likely to have happened than the other version of events. So the burden of proof is a very important distinction between what happens in criminal courts and what happens in civil courts. In criminal cases, there is also a presumption of innocence. A party is innocent until they've been proved guilty. So the burden of proof always rests with the prosecution in general terms. In civil cases, the burden of proof rests with whomever is advancing the argument, usually the claimant, but sometimes the defendant might be advancing an argument in support of their defence. There are interesting exceptions to both of these, but that's a bit too detailed for what we're about today. Another thing that's important is the rules of evidence. What kind of information should be produced in court in support of a claim or in defence against a claim? The court is only supposed to take into account evidence that is presented during the case. So ordinarily they will take into account things that are deemed to be common knowledge. But typically, if we want the court to rely upon something, then we have to produce it in evidence. And as I said before, the courts always have to follow precedents in that lower courts are held by decisions of higher courts. Another thing that's of interest to us is the difference between common law jurisdictions compared with civil law jurisdictions. English law is common law, which is fairly widespread around the world, but is not as widespread as civil law. Common law is an ancient tradition based upon customs that have been in effect for many years, and also on rulings by the Crown. Common law goes way back to the time of the Norman conquest. Civil law is based upon Roman law, so it also has a very strong and ancient tradition. Civil law involves setting out a comprehensive legal code for a nation or for a state. So the most important differences between these two systems is the source of the law, where the law comes from. Common law systems rely on statutes, but they also apply previous judgments, which are seen as more important. So previous judgments in a common law system are more important than statutes. But there is a need for consistency, so the courts tend to abide by the precedents that were decided in higher courts. So the reason for the precedent of courts is to enable this consistency in decisions. In civil law systems, judges have a more limited role because the civil code is designed to cover all eventualities. So the judge merely applies the law rather than deciding what the law should be. And as a result of this, in civil systems, judges have more of an investigation role, whereas in common law systems, judges act as arbiters between parties who present their arguments. So the question often arises, which is best, civil law or common law systems? Well, there are advantages to each. Civil code seems better because the system is more stable, and it seems more fair because laws are explicit from the outset. Common law seems better because it can quickly adapt to changing circumstances, to new ideas and new issues, without the need for Parliament to first enact new legislation. And for practical purposes, many legal systems in the world seem to be a mixture of both civil and common law. There are alternatives, of course, to litigation. This talk about the legal system, the courts and so forth is not intended to be a recommendation that litigation is the best way to settle disputes. Sometimes it is not. It can be very expensive and very time-consuming. So there are alternatives to litigation. And again, this is just a very basic outline of some of the options that are available to people who are in dispute in the construction contract. Because the courts are very important for settling large and complex disputes and for making law. And the courts also are public domain decisions. So anything that is argued in court is accessible by the public, whether by being there or whether by reading reports that record the proceedings. Sometimes disputants would like their arguments to be more private. Arbitration evolved as an alternative to litigation, supposedly to be quicker, to be cheaper, But it's very structured, and it's governed by arbitration law, nationally and internationally. And as a result of the structure that was imposed upon arbitration, often it isn't quite as quick as litigation, and it's often not as cheap. So it's still quite an expensive option, but it's very good if the parties wish to remain private, and there are other advantages to arbitration, which we can return to later. Adjudication is another alternative, which arises these days in English law as an automatic right in construction contracts because of a piece of construction-specific legislation. Adjudication is primarily for disputes that revolve around payment, disputes between a client of construction and the construction contractor. And under this adjudication procedure, an adjudicator is appointed at the beginning of the project, who is called upon to make speedy decisions about who holds the money in the event of a payment dispute until the end of the contract. If the parties are still in dispute at the end of the contract, then of course they can go to arbitration or litigation and fight it out there. The important thing about this, of course, or the point that this flags up, is that you can't go to arbitration or litigation unless the contract has come to an end. So this means that if you have a case that arises during the execution of a project where one or other of the parties wants to litigate, then they would have to repudiate the contract and the contract would be at an end. So the advantages of alternatives like adjudication are that the contract remains alive and it's commercially much more expedient in that sense. And a final kind of option is called mediation. There are a wide range of mediation procedures, and they've all got one thing in common. That is that they're informal procedures that are designed to negotiate a settlement. Contrary to the other types of dispute settlement procedures that we were talking about, mediation does not involve a third party making a decision. It involves a third party helping the disputing parties to come to a negotiated agreement. So there are various ways of doing this, but we won't bother with the details at this introductory stage. The point is that the mediator would help the parties to reach an agreement. Preferably they would document it so that there wasn't some further argument afterwards as to what it was that they agreed. But in this way, parties to a contract can come to a settlement if there's a dispute, an amicable settlement, and move on to an amicable conclusion of the contract. So that concludes this very brisk and simplified summary of how the law works in relation to commercial contracts with specific reference to construction. In future episodes, we'll be looking more closely at how contract comes about and what all this means in practical terms. Okay, thanks for watching. See you again soon.